All right, well, why don't we go ahead and get started? Roshan, if you would advance the slide. Well, welcome everybody. I'm Joanna Lee. I'm the Vice President of Strategic Programs and Legal at the Linux Foundation and Cloud Native Computing Foundation. And it's my pleasure to introduce our speakers today from our partner Unified Patents. I know some of you attending are very familiar with the amazing work that Unified Patents does, but for those of you that are newer to this program, I'll just give you a little bit of history about the partnership, who Unified is, and why we chose to partner with them. Since 2019, the Linux Foundation has been partnering with Unified Patents and a number of other sponsoring organizations and companies to create and fund something called the Open Source Zone. It's a zone of NPE or non-practicing entity deterrence in which Unified helps deter NPEs from targeting open source software through a combination of various tools and strategies, including invalidity challenges, crowdsourced prior art contests, and sharing important information about ongoing threats and patents. And Unified Patents is the only organization of its type, really, that engages in community-driven NPE deterrence. So everything Unified does is community-driven. For those of you who regularly deal with NPEs, you're well aware that part of the NPE business model really relies on companies paying settlements in order to avoid the even higher cost of litigation. So for a single company is often in a very difficult spot even when being accused of infringing a really weak or overly broad or an ambiguous patent. Unified, by engaging a broader community, it has a distributed cost model. The costs of an invalidity proceeding are not borne by a single company, but distributed across many sponsors. Unified also hosts prior art contests and shares relevant information. And Unified has a tremendous track record and success rate, higher than 90% success rate at invalidating weak patents held by NPEs. They host dozens and dozens of prior art contests every year, which the data shows immediately creates leverage in negotiating with NPEs. Without further ado, I'm going to turn it over to our presenters, Sean and Roshan. Also, if you have any questions, please just ask them in the chat. We'll be monitoring it throughout the discussion.
Thanks, Joanna. Unified is very honored to be working with Linux Foundation and CNCF on this. I'm just going to quickly introduce myself and Roshan. I co-founded Unified Patents over a dozen years ago. It really came out of the AIA. Originally, we had, we focused on IPRs, and what we were able to do was essentially have an independent members. We, in the last couple of years, have moved to what we call a re-exam model, where we challenge users. And there's several reasons for that, and we'll go over that in the policy side of things. So happy to explain more of that. In addition, I have with me Roshan, and Roshan actually heads all our challenges. Yeah,
Sean, your audio is a little bit garbled at times.
I see.
Yeah.
Let me
adjust your mic. Well, maybe Roshan can.
Yeah, I think Roshan should take over then until I figure out my mic situation.
Thanks.
Otherwise, it's going to be horrible.
Yeah, you sound
let
great
me do
right
that.
now.
I don't know what's wrong with my mic.
Well, I'll keep it going until we find the mic situation. So as Sean was mentioning, And as Joanna mentioned, we've been using a variety of invalidity proceedings at the US Patent Office and also in foreign patent offices to address sort of low quality patents that are being used in these types of abusive litigation. And as Sean was mentioning, we've been turning more to ex parte re-examinations, which we'll be talking about in a bit. My name is Roshan Mansinghani, and I help run our legal team at Unified and oversee all of the challenges that we file. So this is what we plan to talk about. We've already done the introductions and background. We plan to sort of talk about the NPE threat in the open source zone, what we call the open source zone, but against open source software, highlighting a few very important campaigns that have occurred. We also plan to talk about at a high level the work that Unified Patents has done to try to combat patents being used against open source inappropriately. And then, importantly, talk about some of the recent changes that have just happened in the past few months at the Patent Office that is making defense against NPE or patent troll assertions much harder, and sort of some new thoughts and strategies that you may consider employing as you look at the threat landscape. So as Sean mentioned, Unified was founded in 2012. It's always been community driven, as Joanna mentioned from the beginning, the idea basically being, hey, can we find a way to create deterrence against patent trolls as opposed to every individual company trying to address an invalid patent assertion against them. And as part of that activity, we file invalidity challenges, which is what we're probably most known for. But on top of that, we do advocacy work. We are in the halls of Congress trying to help congressmen and their staffers understand the challenges that happen in this area of patent law, as well as put together unique data, analytics, amicus briefs. We've taken a total approach to try to bring a spotlight to the issue of abusive patent assertions, but also be part of the solution. Unified doesn't exist alone. There are actually a lot of different tools that are out there to try to deal with NPE assertions. We put together the slide to try to help explain them. So we are unique, though, in that a lot of the other solutions, their solutions involve sort of being defensive. So RPX, for example, tries to create low-cost licenses. So NPEs or patent trolls still get paid, but each company pays less than what they would have done had they tried to negotiate with the NPE one-on-one. AST and LOT try to create situations where patents are already licensed before they get in the hands of NPEs. So in some ways, you're inoculated. And the Open Invention Network also has sort of a cross-licensing platform. Unified sort of stands apart from these entities in that what we try to do is create active deterrence. And so the idea being that Unified members are less likely to be sued in the first place because of the membership and the ability to offensively go after patents and flip the script on patent trolls.
I'm going to try this. Can anyone hear me okay?
Yeah, we can hear you fine, Sean. Go ahead, and I'll jump in if you start breaking out.
Okay, next slide, obviously. So we're going to talk about some recent campaigns in a second. But the model of NPEs, if you guys aren't familiar with it really quickly, is they assert, they settle, and they purchase again. And, you know, they're not very innovative companies, although they talk about innovation. Basically, the way you know if their model is working for them is if they do it again and again and again and again. If they don't, then it's not working. And litigation has always been pretty high. It remains kind of at the same level. But in addition, almost all of it is NPE related. So, you know, our perspective on that is that it's a purchase decision. These companies are buying patents with the express intent of monetizing them. And so our goal is to deter that type of behavior, specifically through the support of you guys and CNCF in the open source zone. That's the goal. And to say, listen, if you're going to buy patents, don't buy them in this space because you're not going to make money. And ultimately, our goal is to provide leverage to the zone and leverage to our members to get out if they do get asserted against for less than what they were. The aggregator and third-party assertions are on the rise. Basically, what this is talking about is a lot of the time it used to be smaller entities that would come out and do these assertions. And now there's basically private equity and other large litigation funding entities that are aggregating kind of the buy and the spend on kind of these assertion campaigns. They're more sophisticated. They're, essentially evolutions of the previous models around NPEs, and they are getting litigation funding to basically pay very good lawyers to go out and basically get these big settlements. It means it drives up the cost of the litigation, and it also drives up a lot of times the settlement expectations of these individuals. um, the nice thing is that, again, in all of these cases, they are making rational decisions before they make kind of the purchase of these patents. They do kind of like if you're buying real estate. This is intellectual property, but it works exactly the same way. In fact, there's less encumbrances. They buy it, doing a lot of due diligence, identifying the market that they're going to after, making some determinations as to the likelihood of success before they even make a purchase decision. And ultimately, Unified's goal in all of this is to make those purchase decisions harder in the spaces that we work in. Can we go to the next? As you guys know, the cost of settlement and payment is pretty high. The key thing here is that they work on that on two levels. First of all, they work on the cost of settlement, essentially through the litigation cost. So you're going to incur costs no matter what. A lot of times they can be on contingency or they're investment banks, so they don't have the same cost structure that you have. And they know that, and they leverage that to get a settlement. The second thing is that there's uncertainty. There's a probability that you might get a bad kind of outcome. And so they prey on that as well. And so by doing that, they essentially get these settlements against many different companies with the goal of essentially going after smaller ones, oftentimes first, if they're doing a bigger campaign, and then going after bigger ones because they know once they create a track record of damages and settlements, they can go after bigger companies and ask for similar amounts, and it's very hard to combat. Um, this is some data points. And by the way, I should mention that two things before I move on. First of all, we can share these slides. So anyone who wants these slides, please, reach out to us or to Joanna and her team, and we will happily share it with you. The second thing is that we actually have an event coming up, and it's in November. It's the 13th of November, actually, in Santa Clara, at Santa Clara University. We do it every year, and we'd be very happy to see all of you guys there, anyone who wants to show up, because it's a great place to meet like-minded people in operating companies, and also to kind of see the latest data and areas of interest. So we welcome you there, and it's on our event page as well. Open source targeting has been going up over time, and it's hard to prove a negative. We're hoping that our activities are actually creating a level of deterrence. But one of the reasons why is simply the success of open source and CNCF in kind of getting technologies deployed like Kubernetes and others that are very kind of like ubiquitous, you would say. And basically, an NPE is like an opportunistic virus to a certain degree. Not to make a like complete analogy there, but kind of. But like the reason why they're successful is if they can latch on to as many different technologies and areas as possible. And when you have open source, that's a very fertile ground because they know that if they can latch on, essentially, finding an infringement read on a open source technology, they can go after many, 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 many companies with the same assertions. And that makes it much easier for them to justify their kind of business model and go out and purchase things. And so that's the problem. But the nice thing about a lot of these patents is oftentimes they're just invalid. And so that's where we get involved in as well. Can we go to the next slide? So an example of this is a recent one, and we think is pretty entertaining. It's called Artificial Intelligence Industry Association. And it's not an industry association, and it's really barely about artificial AI to some degree. It's about stitching pictures together and other things that AI does sometimes. But basically, they claim that they're going against AI companies that are doing all kinds of combinations of different things. And they've gone after, and they're playing this kind of NPE playbook to the hilt. Like, it's kind of entertaining to watch to some degree and kind of sad at the same time. They basically have recently sued a bunch of really small companies. And the only thing that we can imagine why they're doing, and typically this is the case, is they want to create a track record of damages and settlements. So then they can lever up and go after larger companies that are doing similar types of things. And when you look at their website, it looks kind of legit. It looks like an industry association. They talk about memberships, but their membership model is literally you buy a subscription to their license for their patents that they purchased from a bunch of different companies. And they basically say, if you don't take a license through our subscription, we're likely to sue you. And it's a pure NPE in every way whatsoever, except the name. But these are the examples of what they kind of, some new entities do, and these are new examples of what's happening in open source. I'm going to hand it off to Roshan to go after, discuss some of the other campaigns, but we thought this was particularly like an entertaining one. And we're actually actively like working on getting prior art set up with this, so that it can help out not only the small companies that are like this, that need leverage and help, but also the larger ones as they create demand letters and come after other, like more companies with their campaign.
So turning back to some of the more well-established campaigns, we highlighted 3 of them here for your consideration. Each of these are litigation funded, and each of them kind of go after a different slice of the industry. So I'll start with Valtrus. Valtrus has been litigation funded by an entity called Centerbridge Partners, partnering with a licensing entity called Key Patent Innovations. Valtrus has over a dozen patents in which they are focusing on key cloud-native technologies. I've listed them here. They have been sending letters to many companies and then suing as well companies such as NetApp and FedEx, but several others. The industry has responded in the sort of bilateral way where they have been filing challenges against Valtrus's patents in using the inter partes review or IPR process at the Patent Office. Unified is continuing to monitor this campaign, and if we see opportunities to get involved, we do. We have been contacted by many of our members regarding Valtrus. We've had active discussions with CNCF about Valtrus and have funded prior art searches to try to help industry defeat the Valtrus patents. To give you a sense, Valtrus is typically looking for, and frankly, all 3 of these companies are in the same boat, but to give you a sense of what some of the numbers around what Valtrus is looking for, they are looking for tens of millions of dollars. And so what that means is that if you're facing a tens of millions of dollars demand as an individual company, you now have the legal budget to actually fight them in district court and in the PTAB. And again, the way that Valtrus is able to do this is because there's essentially a private equity company, Centerbridge Partners, that has a general fund, and part of that fund they have sliced off for funding litigation, including patent litigation. Digital Doors took a different approach. Here, they are going after an open standard in the financial space on how financial documents are stored with security measures on several servers. But when you look at the patents, they sort of are really dealing with storing data in different servers using different confidentiality or encryption standards. And they have specifically focused just on the financial industry, so banks and financial bank technology providers. We have challenged one of their patents and are looking at challenging more. Others have filed challenges in the industry as well. But again, when you look at the patents, and this is true of Valtrus as well, the patents don't actually say anything about financial documents in digital doors. Instead, they are talking about taking a document, parsing the text, finding confidential information, storing it in separate places. This is one I'm personally involved in. I actually had a call about it yesterday, so I'm pretty up to speed on it. And again, the point is they are asking for millions of dollars from each of these entities that they're suing because they think their patents cover a particular banking standard on how documents are stored. Finally, Malikie is another important campaign of concern. So Malikie has a bit more of a backstory than Valtrus and Digital Doors. It also involves Key Patent Innovations and Centerbridge, the same folks we talked about with respect to Valtrus. But in the Malikie case, BlackBerry, about 5 to 7 years ago, had a strategy for helping their company sort of pivot. And part of that strategy was to sell off a bunch of their patents that they didn't want to carry the weight for in hopes of driving and creating licensing revenue as another important revenue stream for the company. So that sale was actually fairly public, and usually patent transactions are not public. But because it was from BlackBerry, there was a lot of coverage on it. And there was a sale of hundreds and hundreds of patents that now has to bring a return on the investment. The amount of money that was poured into buying the patents from BlackBerry was in the hundreds of millions of dollars. And so, as Sean mentioned, a lot of NPEs follow a fairly economically rational playbook. And what's interesting about Malikie is that because the actual deal itself was so public, we actually know what their essentially what their target returns are. So they spent hundreds of millions of dollars to buy the patents, and now they have a pretty short window, about 5+ years, to get a return on that investment. So they've been very aggressive, filing lawsuits, sending a bunch of letters, and they've taken this corpus of BlackBerry patents. BlackBerry kind of kept the core messaging patents and the things that they're sort of known for, but they had a whole panoply of patents related to, for example, Wi-Fi, but also related to things that are related to open source, including, as we mentioned here, network address translation, CubeFS, Vineyard, a bunch of patents that cover a variety of cloud technologies. And so what BlackBerry is doing is filing litigations on sort of dozens of patents against a variety of companies, but looking for what we would call a portfolio-wide license, right? So their licensing demands are also in the millions of dollars, but they need to hit. They sort of have very aggressive monetization targets, and so they need to hit a lot of companies fast to start trying to get a return on the hundreds of millions of dollars that was invested in buying the patents from BlackBerry in the first place. So they are an entity that really just needs to continue to hit loss after loss in order for them to stop, because they just have so much money at stake that they need to keep going. And so we have already challenged 3 of their patents in the summer. We sort of have done a lot of work trying to look for more prior art to challenge even more of their patents. So if you want to learn anything more about BlackBerry, please feel free to reach out, or Malikie, excuse me, please feel free to reach out to us. But these are sort of a flavor of some of the most important and expensive litigations that are happening right now. What we then did was try to give you a sense. I'm not going to go through every row on the tables of these next slides, but give you a sense of what kind of entities are asserting, what kind of work has been done to try to deter that assertion, and what kind of open source software has been at risk. And the bold in the open source software column represents times when the NPE has actually named that open source software in the complaint. The others are open source software that is analogous or related to the actual technology accused in the complaint. But this gives you a sense of the volume of the assertions that are happening. As you can see, open source is being attacked on a monthly basis, and sometimes, multiple times a month. And that's what these slides are intended to show you, that especially in the cloud native space, there is a lot of assertions happening. And then the final column of this set of slides shows sort of the deterrence work that's been done either by Unified, which is in bold, or other challenges filed by companies that are facing these lawsuits directly. So Data Cloud's an important entity that has explicitly been challenging virtualization software that's part of the Linux kernel and Kubernetes. In this next slide, we have SoftView that has been asserting against Android's WebKit and the Blink open source software. And as you can see, Unified's been doing a ton of work to try to get almost 80% of the campaigns there, but we don't have enough resources to go after everything. And so you will see some of the blanks that are happening here. And importantly, what you can see is that while Unified's been doing a lot of work to try to challenge these patents, as well as other industry players, some of these patents just never get challenged because the financial resources are not there. In 2025, we've seen a lot of challenges to open source, including, for example, Xmatrix that explicitly sued QNAP, which is an important vendor that includes open source software in its products. Arlington Technologies by a company called Dominion Harbor. Dominion Harbor has been monetizing for almost 20 years now as a patent troll. They've been at it for a long time. And they bought a portfolio from Avaya. So this is sort of similar to the Malikie story, where they bought a portfolio where BlackBerry divested a huge portion of their patent portfolio. Arlington got it from Avaya. And now they have, you know, not as large as a Malikie portfolio, but fairly large. They have been asserting in letters a bunch of patents that we've been able to challenge as well. So this set of slides, you know, we're into about 5 or 6 slides, kind of shows you the volume of stuff that's been happening in the space. VPN technology is another important one, where they've gone after VPN technology, as you might imagine, given their name. So now we're going to turn to some of the work that Unified has done specifically to try to challenge some of the campaigns that you've seen listed in the previous set of slides. And again, huge number of actions. We've given you a status of sort of where everything is at in the process, if you're familiar. We've again listed the open source software in the middle, again, using the same convention that bold indicates that they actually mention these open source software projects in the complaints versus just accusing sort of what that vendor provides when they sue them. And so Unified's been very active in trying to attack these patents. And if you'd like any sort of more information about this, again, we're happy to share that information as well. But we've been going after some of the most important patents being asserted against open source technology. And we love hearing from the community as to which ones they find to be important, because it helps guide our process in identifying what is the most relevant to the open source community. So this gives you a flavor of the work we've been doing. You know, Intellectual Ventures is another sort of important entity out there. They're very famous, sort of like started through a partnership with Microsoft a long time ago. And it's sort of, the Intellectual Venture story is interesting. Sean can chime in on it, but basically the idea was, hey, let's sort of keep patents off the market so that they don't get asserted. But then sort of years later into the process, they sort of had all these patents, they're paying maintenance fees on these patents, and they're like, hey, why don't we start asserting them? Almost exactly the opposite of what they were started to do. And now they've become one of the most notorious patent trolls from the past decade. And recently, Intellectual Ventures has acquired a portfolio of patents that they're directly asserting against Kubernetes. They mention Kubernetes in their claim charts, and so we've been that's been another important focus of ours, is to address Intellectual Ventures and their attacks against open source. Sean?
Yeah, like just to chime in on Intellectual Ventures. Intellectual ventures, and I'm not like, this is not hyperbole, was literally a kind of pyramid scheme, but it's a pyramid scheme where if you don't join the pyramid, they can sue you, basically. Uh, and at first they said, "Oh, you can just join the pyramid scheme. Everyone should join the pyramid scheme. It'll make you everything better, and you'll avoid everything." But then not everyone wanted to join the pyramid scheme. And then they said, "You know what? If you're not going to join, like with money, you're going to have to like get sued." And so it's just kind of been interesting. And you just can't just join one pyramid scheme. They made like multiple pyramid schemes basically, and you had to like sign up for all of them. So it's very interesting to kind of see how it played out. Anyway, that's just one other thing. Like, if we can go back to the AI slide, guys, just for a second. One of the things that I guess is important to understand and why Unified exists is exactly these situations. Now, you guys aren't seeing this litigation probably right now. These are very small companies that they're going after. But this is when you want to create that deterrence. This is when you want to like actually challenge the patents. They're going to come to your doorstep at some point. They're going after small companies that simply don't have the resources to defend themselves. They know this on purpose. They're doing it by design. They're basically preying on their litigation costs and uncertainty to get settlements out of them for maybe not that much money, but actually from a kind of per user perspective, or from a kind of another metric that they're going to use, it's going to explode the damages as they go after bigger companies. And that's why we get involved right now, because we know that later it's too late. They already have created that track record, and they're basically going to go after the larger companies with that track record, ask for lots of money, and it's very hard to do anything about it at that point. And also, once they've started making money, it's only a question of how profitable they're going to get. So our goal is, if you can start early enough in this process to deter kind of these types of activities, you can kind of reduce the chances that not only these people will come and be able to assert against other companies in this space, but also the next entity that makes an investment decision will say, listen, maybe it's just not worth it. Maybe we should buy a patent, I don't know, like, med tech or something like that, or Bitcoin. But, buying a patent here, because there's basically an unlimited source of patents in this world to go and use and assert, is maybe not economical for us, because we know that we're going to get challenged right off the bat before we start like making money. And that's not going to be very, like cost efficient for us. Anyway, so back to you, Roshan.
Thank you. Yeah, no, super helpful. And I saw that Joanna helpfully put in the chat what we mean by something on this slide when we use the term patrol. So I'm going to talk about that briefly. We have some other slides on that later, but it may make sense. So when Unified was created, as I mentioned, we've always had community in our mind. It's sort of in our name. That's what the word Unified stands for in the company's name. And Patrol is sort of the only type of its kind. It is a crowdsourced prior art contest platform that the company created and that Sean spearheaded. So the idea is we essentially put a bounty on a patent. We say, hey, here's a patent. Community, come and support. Sort of leveraging the wisdom of the crowd. And if you support, if you find the research that shows that this patent is invalid, we'll reward you. So we have done, I was gonna say dozens a year. So hundreds of, at this point, of these types of challenges. And it's been very successful. And as Joanna mentioned at the beginning, it's sort of helpful to also for companies dealing with these NPEs to see that they have, that their patents aren't just bulletproof, but that they have real quality concerns. So turning back to our set of slides, we also wanted to look back in history, some of the things that we've done to try to invalidate a bunch of patents that are out there, and also show some of the shots we've taken on various entities in the past. So that's what this set of slides is about. And now we wanted to jump to what I just mentioned, which was this Patrol prior art contest. So again, another table of slides. Obviously, the point of this presentation is not to show you or walk through line by line what each of these tables represent, but to give you a big picture view of all the options that you have available when trying to deal with NPEs. So we've put together this and showing you that we've gone after some of the more smaller NPEs and the ones that have the most funding. And we have found that we've been able to use the resources of the crowd and the community to leverage that and effectively and very cost effectively provide pressure upon the NPEs. So this set of slides gives you a flavor of that. Sean?
Yeah, sorry, I'm chiming in with color commentary. I was at a football game yesterday, so this is like my Al Michaels moment. So with AI, by the way, we're doing some like really interesting new stuff. Patrol was crowdsourcing from essentially using humans, and now we're doing AI-based prior art and claim charting and other things. That's especially important in situations where you have very large entities, where essentially you have hundreds of patents or even dozens of patents. And it's just simply uneconomical to have either, contests or challenges against everything. But there are ways with AI and with the capabilities that are, really just coming into the marketplace right now to really like actually take the battle to them and create leverage that simply wasn't possible before, in my opinion. And I'm happy to kind of go through that at some point if it's interesting for people. But basically, you really can go after patent holders that have even thousands of patents, and that's a big kind of interesting new way of kind of creating leverage that wasn't possible in the past.
That's right. So as you can see, a lot of work has been done in trying to find prior art and to apply pressure on NPEs that otherwise basically wouldn't experience pressure outside of these types of activities. NPEs, as mentioned at the beginning, sort of leverage the fact that bilateral negotiations are very expensive for the companies on the receiving end of the patent demand or patent lawsuit. And so our approach has always been, how can we disrupt and flip the table on the expense and democratize the expense? So now the NPE is the one that faces the Hobson's choice on whether to assert and how to do so in a financially effective way when there's a third party like Unified out there creating deterrence. So as I mentioned, there have been some changes at the Patent Office that occurred this year that have unfortunately tipped the scales in the favor of NPEs and patent trolls. And now this set of slides is going to sort of talk about that and what are things that can be done even with those challenges. So specifically, the Patent Office has an interim director, an acting director, who has completely changed the landscape of a certain type of challenge called inter partes reviews, or IPRs, that Congress created back when Unified was started, as Sean mentioned, the America Invents Act, or the AIA, to streamline the issues of validity for litigants so that they don't have to pay millions of dollars in district court just to prove that a patent was invalid. Why not just spend on the order of hundreds of thousands of dollars, low hundreds of thousands of dollars to the patent and use a proceeding through the Patent Office, which was the agency that granted the patent in the first place. So it sort of made sense to industry and sort of moving forward, and Unified was sort of founded around it to say, okay, now we've got a procedure by which we can really test the validity of patents in a cost-effective way for everybody involved. And so on the left-hand side of this slide, we have a pie chart that just simply shows that 2/3 of challenges were instituted. So the way that this process works is that a person wanting to challenge the patent files a brief, essentially, with the Patent Office. the patent owner has a chance to respond to it, and then a panel of 3 patent office employees, which are called administrative patent judges, look at it and decide if there's enough merit for the case to move forward. So it's an initial look by 3 patent office judges to decide if the case has enough merit, and then they go into the full proceeding. And so that initial stage is called institution, whether or not the petition will be instituted. And as you can see, 2/3 of the time, going back all time, so this starts from like basically 2013 to 2024, 2/3 were instituted. And the major change, as you can see on the right-hand side of the slide, is that starting in this calendar year, institutions have plummeted. And it's not because the quality of the challenges have been less. Rather, what has happened is that the Patent Office has decided to use a right that they have called discretionary denial. So the way the statute is written, it basically says the Patent Office, even if there's a meritorious challenge, can still exercise discretion to not institute the case. And there was, prior to 2025, the use of discretionary denial was not very rare, but rare. There was only a subset of cases where that sort of made sense. Typically, what the Patent Office was concerned about was duplicative proceedings. So, for example, if you have a district court case that's going to go to trial and validity is going to be addressed at the trial, and you also have this co-pending Patent Office challenge that was going to come out and still be worked on while that trial was moving forward, it would seem to be an ineffective use of Patent Office resources to address a patent with the same parties that were also addressing the same issues in district court litigation. So that was an example where you had at least some sense of like why they would not institute a challenge even if it was a meritorious one. But now, through that small wedge, the current acting director of the Patent Office has blown the door wide open and is now denying the vast majority of IPR challenges. And this slide sort of explains why. So now the burden has been put upon the patent challenger to provide reasoning why an inter partes review is an appropriate use of office resources. Now, from a petitioner's standpoint, Congress has created this process. So it is a little strange to now have the burden to explain why that's the case. These challenges are not inexpensive. They cost a couple $100,000 even just to put together, and tens of thousands of dollars in filing fees with the Patent Office, because you are getting the time of at least 3 Patent Office employees to look at it. So we tallied up, and these sort of over 100 plus discretionary denials, almost 200, has costed industry and the players $4.5 million in the work that they did to put together, only to be denied on discretion on factors that were totally new, totally made up in this calendar year versus what had been done before. And importantly, when cases are actually referred to a panel, so they make it through the discretionary denial gauntlet, 70% of the time they're actually instituted because they are meritorious challenges. So one of the biggest factors that they are now using, which is new, is the age of the patent. So regardless of when the patent was asserted, if the patent is 6 years or over in age from when it was first issued, the Patent Office has now said, and this is again new in 2025, that a patent owner has so-called settled expectations to the rights of their patent and can assert and not be worried about the Patent Office, at least through this procedure, taking a second look at the patent. Now, this is completely divorced from reality because, as we've shown previously, patents are bought and sold all the time. And so it's not that the buyer of the patent has any form of settled expectations. And also, patents are often asserted well into their life. They're not asserted in litigation from the very beginning. So even if they were to stay with their original owners, this idea of settled expectations just doesn't match the reality of how patents are licensed or asserted. So,
so
go ahead,
yeah,
Sean.
this is Sean. Yeah, so in fact, I mean, they talk about settled expectations, but the thing is that, what they're doing is making things unsettled in the litigations, because basically the use of IPRs in these situations has kind of become very iffy at best, given the likelihood of failure at this point. And most NPEs are purchasing long in the tooth patents. So these are patents that have been around for a very long time. They're the end of life typically, and they want to monetize them, or whoever's selling them wants to monetize them as much as they can. And so the idea that and this is what the patent office is really saying, is that if you want to challenge these patents, you got to challenge them when they come out, not when they're suing people on them. But I mean, practically speaking, that's impossible. That's like saying, predicting who is gonna like go nuts or something like that. You just, like, out of millions of people, you have no way of predicting which one, and how are you going to spend the resources to try to figure that out. You have no way of having the resources to figure that out. So the idea that you can somehow figure out at the time that people are getting patents which ones are going to be potentially used, given how many of these are just inherently invalid, is simply just not credible. But that's the way kind of the patent office is doing this. And really their goal, and they've made it, I think, transparent from the beginning, is that they expected originally, when the AI came out, and this is public information, they expected to get 500 filings a year on average. And they got more than 1,500 every year. And the interim director has essentially said, we want to get that back down to 500 filings a year. And so, which is what we thought it was going to be. And so that's what they're doing. They're finding ways to ding people and to essentially make it so that you and other companies are not incentivized to file IPRs in any way on assertions, and to just do something else, or just litigate it, which is even more expensive and leads to bigger settlements.
That's right. So looking at the options that you have, other than just going to trial in your district court litigation, which costs millions of dollars, IPRs was one of the strategies. Ex parte re-examination is another. So the patent office, I guess somewhat confusingly, but I think beneficial for the community, has two processes by which you can challenge a patent: IPR and ex parte re-examination, or EPR. And the EPR is about half the cost of IPRs, because unlike an IPR where the petitioner gets to stay in the challenge, gets to have an oral argument, gets to take depositions, in an EPR, the only thing that you do is you file your challenge, you submit effectively a brief, and then you're out of it. And then at that point, that's why it's called ex parte, because it's only the patent owner and the patent office that then deal with the challenge. You're completely out of it. Now, of course, litigators don't like that. I totally get it. I didn't like it either. But what we have found, by being one of the only companies, in fact, I think the only one, that has really stress tested the EPRs by filing dozens and dozens and dozens of EPRs, is that the success rate's actually close to IPRs. And importantly, they're half as expensive, and there's no estoppel. So what is estoppel? In IPR, if you make it all the way to final written decision, you lose as a petitioner, there's a certain set of arguments that you cannot bring in district court anymore. So essentially, Congress's idea was, look, pick your validity fight in one forum. You can't get two bites at the apple. If you're going to pick IPR and you lose there, you can't bring the same validity arguments in the district court. With EPR, there is no estoppel. So that means you can file multiple challenges in ways that are just not possible with IPRs. The other options are 101 motions in district court. It's limited scope, and depending on which judge you're in front of, the success rate is very volatile. You can do summary judgment motions, but you have to wait till you get all the way through litigation and discovery before summary judgment motion. And then you can also look for prior art, and I think our tools are helpful for that. And Cloudflare is another company that's involved in that. But that doesn't kill the patent. It just means you now, if you will, have the ammunition to be able to go after the patent. But then you still have to choose, again, summary judgment, trial, ex parte reexamination, or IPRs or inter partes reviews. So what the new playbook here, the new option in the playbook that we've kind of pioneered in the sense that we've stress tested it is ex parte reexaminations. So one of the benefits of ex parte reexaminations, as we mentioned, is that there's no estoppel, but these are the stages of ex parte reexaminations. We thought this would be helpful because there are not a lot of people that are sort of familiar with it. Each one of these stages offers sort of opportunities for settlements. So one of the things that IPRs were very popular with was that if you filed an IPR, you could settle it. If you settled your case with the patent owner, you could then settle your IPR, and then the patent owner's patent would survive. So this is sort of a negotiation tactic where the patent owner still had some stake in it. One of the reasons why ex partes were disfavored prior to this calendar year was because there was no way to settle. Once you filed it, you were sort of out of it. But that's not exactly the case. So yes, you can't settle it. Once you file it, you're out of it. But there are ways to be able to get involved at each one of these stages. Each one of these stages allows for sort of a different point in the negotiation, because as you progress through these stages, the chances of patent owner success go down, right? So that could then change the settlement numbers that can be used. And importantly, just because they win one ex parte reexamination doesn't mean they'll survive the next. You can find other prior art, and you can use that in settlement negotiations and as leverage. Whereas in IPRs, once that completed, it gave patent owners sort of a final place where they could say, okay, we beat you, now settle with us. So I know we have just a few minutes left. I want to make sure that we give time for questions.
I'm not actually seeing any questions in the chat, but I just wanted to chime in and, oh yes, please do speak to this slide, Roshan.
Absolutely. So as I mentioned earlier, Unified has been using ex parte reexams actually since we first started as a company. Our first challenge was an ex parte reexamination. And then a few years ago, we decided, after looking at the data and carefully studying it, that reexaminations would actually be kind of a better use of our members' funds, because if we can get similar success rates at half the cost, why not? And so we have been filing nearly 100 reexams in the past couple of years, and have really seen where the benefits and the strategies come in that are slightly different than IPRs. And so if you compare us with ex parte reexaminations, you can file them anonymously, and so it's just a filing law firm that's listed. So the way we did these counts was, instead of counting parties, we counted law firms, especially since law firms then sort of get to also represent a variety of clients. And as you can see from this slide, we are just the ones that have filed the most and have been the most successful, because our company has invested a ton of resources into understanding ex parte reexaminations, using them in volume, in mass, and seeing where they are beneficial. So this slide kind of shows the sort of the result of all that work and analysis.
Yeah, I just wanted to chime in and point out that this is such a powerful, cost-effective strategy. EPRs are cost-effective sort of to begin with, and Unified, because they're so experienced at this, they can do this in a very efficient manner. And the costs are spread across all the sponsors of the open source zone. So it's there's also the community-driven aspect of it. But Unified has far more experience than any law firm at EPRs, and they really understand the NPE space. So I'm just, I do, and they are available if you want to sponsor a re-exam through Unified. That is a service they offer. If you're not a Unified member, you can still sponsor. You can co-sponsor it and share the cost with other organizations as well. So please do consider this as part of one of the options for your NPE Defense toolkit. Also want to mention, because EPR is a little different from IPRs in that you kind of throw it over the wall, and I mean it is more nuanced than that, but you throw it over the wall and then you can't really withdraw it. So where are the settlement kind of leverage timing points? Combining one way to create, expand the timeline is to do a patrol contest, a prior art contest, as an intermediate step before you pursue an ex parte re-exam. And we found that strategy to be very, very effective. The data shows, so sometimes even before the prior art is actually found and published, just Unified announcing that they're going to host a crowdsourced prior art contest can immediately drive the amount demanded by NPEs as settlement, can immediately reduce the asking price. And then once the prior art is published, of course, you see a further reduction. And then when we start talking about pursuing an invalidity proceeding, that creates further leverage. And there is a question in chat.
Yes, I see it. Thank you for the question. So the question is, how do you deal with the downside of EPRs where you cannot participate in the examination? That is, you may have a rebuttal that you can't present unless you file another EPR. Those are great questions. So one of the ways we deal with that is we anticipate the responses that the patent owner may make, right? So you can't do that perfectly, but you also shouldn't present an EPR with just your best face forward without understanding the nuances and the complexity of what the patent owner may try to argue. So that's one thing that we've done. Another thing we've done is shown the examiner how the patent owner is actually asserting it in litigation through their complaint, so that they try to say two different things, which patent owners often do, unfortunately. The examiner is at least aware of it and can deduce when the patent owner may not be telling them the full truth. The third thing that we've done, and I think this is really important, is that we have made sure that our ex parte re-examinations are clear for the examiner. So previous to us and the work that we've done, the typical way, if you looked at how re-exams were filed by others, years ago, was you just kind of throw as many claim charts as the examiner, hoping they find something that sticks. And then hoping what the examiner does. And what we've seen is that, frankly, the examiners don't have time to look at all of these, dozens and dozens of claim charts. So if you kind of stick with some of your best arguments and make it very clear for the examiner, reduce the complexity, the examiners actually do a fairly good job, right? Because you didn't force them to look at dozens and dozens of claim charts. You made their life easy. So our mantra internal to the team, what I tell the team all the time, is how do I make my examiner's life easier? What can we do in this request to make our examiner's life easier? If you do that, frankly, they do the rebuttals for you. But in the odd case, and again, it's a sort of an 80-20 thing. 80% of the time, we've seen the examiners do the right thing. 20% of the time, they've gotten confused. You can just file a second one, a second re-exam. And you can do it while the first one's still pending, by the way. You don't have to wait till the end of that one. So you can basically write it up and say, look, there's this other re-exam. They made this argument. Here's some new art. And you're able to get in front of the examiner again.
Great, thanks, Roshan. Well, we are out of time, so we're going to wrap up. I've posted our contact information in chat, so feel free to reach out to any of us if you have questions, would like to learn more about the open source zone. We're also happy to share the link to the slides. And Linux Foundation Legal Summit, which is for counsel at member companies of Linux Foundation, is going to be next month, and Unify is going to be giving a presentation there as well, and hope to see many of you there. I posted the link to that event description chat as well. So thank you so much to the Unified team. Thanks, Sean. Thanks, Roshan. And thank you all for attending.
Thank you, everyone.
Thanks, everyone. See you soon.